right now we're in the motions are being written. Obviously, yesterday, I'm sure most people have discovered by now or seen that I filed a motion letter with the judge asking for permission to participate in the Daubert briefing.
Just about 8 hours ago, Attorney John Deaton was on a Linqto Twitter space, and that lasted for over 30 minutes. What I've done here is taken some of the nuggets of importance to help you with your time management and get right to the facts of what is most important to understand the motion he just filed. Linqto, they continue to increase their participation in this space. They have over 55,000 members now that are in their network. And with the overall vision to democratize investing, they want to transform the ways and let the smaller retail investors participate in the pre-IPO shares of these private companies. Many of them are unicorns. Do you know that they are building a new exchange on the XRP ledger and talking to the SEC to explore how they can get a special regulation that allows them to expand beyond the accredited investor? So that is why you definitely want to sign up using the link in the description below of this video. Stay close to them. And in the meantime, enjoy the content that they deliver a few times a week. Now, John Deaton, he does a great job at explaining the best case scenario and the worst case scenario, and also why there's no way that this expert, Patrick Doody, who's been retained by the SEC, should be allowed to testify, especially if he is using some wild speculation. Did he even talk to an XRP investor? Let's let John answer that question.
What Daubert is relates to expert witnesses. And Daubert is from a famous U.S. Supreme Court where the Supreme Court adopted what the standard is for allowing expert witnesses to testify. And the bottom line is when you have a Daubert motion, what you're doing is you're challenging the ultimate opinions of the expert because their methodology, how they derived at that expert opinion is flawed. And so basically you're going into court and saying, Judge, this particular expert should be completely disqualified because they don't have the requisite qualifications, or this particular part of their testimony should not be accepted by the court because it is so deeply flawed. So that's what a Daubert motion is. But the bottom line is I sent letters that are now exhibits to my motion to the SEC and to Ripple saying, hey, I may need to participate in the Daubert motion or with summary judgment, and here are some potential relevant issues, to get some feedback from them. Are they willing to agree that I could view non-public information? So as amicus counsel, I'm not privy to all the stuff unless it's filed publicly. So for example, the Hinman deposition, the people on this call have seen exactly what I've seen. I haven't seen the unredacted versions of the Hinman deposition because I'm not a party. All right. And so basically in requesting information, I found out that there's this expert witness that the SEC is using, and his name is Patrick Doody, Doody. And he's basically offering opinions similar to what he did in the Telegram case. Is basically he's going to say that XRP holders, and I haven't seen his report, so this is a bit of me speculating, but I'm pretty accurate, I believe. He's going to say that XRP holders, when they purchased XRP and acquired XRP, they were relying on the promises and inducements of Ripple. And that's the reason they acquired the XRP. So I believe that Patrick Doody is being used by the SEC to try to establish that even secondary market XRP, not people who bought it directly from Ripple, but when you go on Coinbase or Uphold or Kraken and you buy XRP in the secondary market, that you bought it relying on Ripple. Now, we all know that a lot of people, they heard the name Ripple because it used to be called XRP, but they purchased and acquired XRP without knowing about the company Ripple. And so basically, I found that out. I asked the SEC and Ripple would they agree to share his report with me. Ripple said yes, because the SEC didn't name it listed confidential. As soon as the SEC found that out, they objected and then labeled it confidential immediately. And so I went to the judge saying, basically, in addition to the summary judgment motions, I should be able to participate on behalf of XRP holders in this motion, that there's no more relevant maybe motion. If this guy is going to get up here and say what we believed or relied on, we should be able to participate and give her our perspective. In my letter, I explained to her that I have served Ripple and the SEC with 3,252 affidavits, basically from XRP holders in multiple categories. I've collected these affidavits from XRP holders, in the last months, and they say things that are just basic truth, right? But a judge might not know. For example, there's an affidavit that says, hey, I staked my XRP and I acquired a interest on it, and I didn't need Ripple to do that, right? So that takes you out of the Howie factor, relying on the efforts of the other. Or I collateralized my XRP for a fiat loan. Well, there's a financial benefit without Ripple. Turns out when you add up all the percentages, the majority of first-time acquirers of XRP were unaware of the company Ripple. So it's very relevant to challenge this guy. I predict that this expert gave his opinion and didn't interview one XRP holder. That's my prediction. Now, I don't know that for a fact, but that's my prediction. So that's where we're at. First, best case scenario, the judge grants exactly what I asked for, and that is that she would tell the SEC to provide me with the Doody report now, or before July, as well as his deposition testimony, because Ripple deposed him, right? There were all these depositions that everyone knows about. Ripple deposed him, and I need to read that. What's the basis of his opinion? Like, did he interview any XRP holders? What forms the basis of his opinion so I can write a brief? So that's the best case scenario, and she would rule, that fairly quickly. Best case scenario, she'd look at it and say, this makes perfect sense, not even listen to the other sides, but chances are she's going to let the SEC file an objection and let Ripple file a response to my motion. Sort of like my pre-motion letter on the motion to intervene. Typically, the other side has 5 days to respond. So we could get a response from the SEC, either Friday or a week from tomorrow or sooner, or from Ripple, and then she could rule, the next day after receiving their rulings. Now, worst case scenario, she says, Deaton, Ripple has enough adequate attorneys. I believe that they can adequately represent the interests of XRP holders in attacking or challenging Mr. Doody's qualifications or his opinion. And even if she says that, a lot of times, XRP holders and people generally, they only count the wins and the losses, right? Well, even if that happens, even if she says no to me, we still got the information in front of her, right? That she knows that XRP holders didn't just sit on their butts, man. Thousands of people took the time. There's 1,500 of the affidavits are sworn, like meaning they went to a notary and had them sign it. And, you know, they deal with all the issues that are relevant. And if this guy is going to be used, Doody, by the SEC, in essence, everyone knows the Howey test. In essence, he's being used to establish the common enterprise prong and relying on the efforts of others prong. So he's a big, big deal. And as I'm explaining to the court in my letter, right, what's crazy about this case that everyone's heard me preach about so much is that the SEC is taking the position that all XRP are securities, including the secondary market of people who purchased it in the secondary market who've never heard of Ripple. And so in my letter, I submitted and quoted Judge Netburn in that very first hearing where she said to the SEC, well, according to your theory, every person in the world trading XRP is committing a securities violation. And so, you know, I'm confident that she'll grant it. Now, it is possible that she says to Deaton me, denied for now, I'm going to wait until the briefs are filed, and then you can reapply, you know, and give me a proposed brief, and then I can read it and decide whether I'm going to accept it, because she doesn't want a duplicative argument of Ripple. So there's all kinds of, you know, different ways that she could rule, but I felt compelled when I heard that they're going to rely on this guy, and he's going to get up there and tell everybody, you know, what the reasonable XRP holder relied on, that it's something that we should be involved in making sure our perspective, not just Ripple's perspective. And one thing that I encourage everyone to read is the judge, when she granted amicus, she said in her ruling that the XRP holders may view XRP differently than Ripple, and that may provide a unique perspective. And so what I did, look at footnote 3 of my letter, I said to the judge, you're 100% correct, not these words, you're 100% correct, Judge. And then I cited the paragraph in the complaint where the SEC says Brad Garlinghouse said he doesn't view XRP or Bitcoin as currency. He doesn't buy coffee with it. James Rule will appreciate this. Footnote 3, I said, well, Judge, you're 100% right, because XRP holders, some of us do view it as a currency, and we do use it to buy our coffee, including at Starbucks. So hopefully she'll see all that and grant us permission to be heard. So I didn't submit the affidavits to the judge. I submitted the affidavits to Ripple and the SEC saying these affidavits form our perspective, because if you look at one of the exhibits, the SEC, of course, did what it always does. When I asked questions and they said to me, you know, if you seek permission to file a brief, we may ask for an extension, you know, to respond. And so to show the judge that that's completely unnecessary, what I did is I served them with all the affidavits, declaration by me and whatnot, and simply said, these affidavits form the basis of our perspective, so there'll be no surprise to the SEC. But it'll be up to Ripple to utilize the affidavits or not use the affidavits any way they seem fit. I can't present evidence to the court. The judge put that limitation on me. So need to make sure that that's clear. So it's sort of up in Ripple's and the SEC on how the affidavits get utilized. As I explained in the letter to the judge, you know, she said that she wanted to hear our perspective. It could be unique on matters that are very, you know, relevant to us. And so as I wrote in the motion to her, it's hard. It is very difficult to imagine a more singular, pertinent topic for XRP holders to be heard than the issue of what XRP holders relied on, you know, in acquiring XRP. And, you know, the truth needs to matter, right? It shouldn't just be the SEC. We may see the SEC literally move uses or the affidavits. They may actually, we may see our Security Exchange Commission at the court to ignore the evidence and the affidavits on the issue, because of whatever reason. So I'm jazzed because there's no way that this expert should be allowed to testify to wild speculation. For example, when he's cross-examined by Ripple, and I haven't seen it, but I can only imagine they're very, very good attorneys. They're going to challenge the foundation of his opinions. For example, first question, how many XRP holders have you interviewed? If the answer is 0, which I think it's going to be, then why do I think it's going to be? What's he going to say? That he made this call? He's not going to do that because he's not going to take the chance of getting the answers he doesn't want in order to testify to what he's being hired to testify to. And he's not going to be able to say, well, he advised some of his friends because he would have advised them to buy an unregistered security. And I've been doing this long enough for 20 years, and I've deposed a lot of these types of experts. I just know that he's going to have no, basis. And in the Telegram case, it's so different. And I'm very worried about the judge because in Telegram, I pointed out this to the judge, Judge Castell, which is in the same Southern District of New York. He cited Patrick Doody's report 7 times in his decision granting summary judgment to the SEC, granting a preliminary injunction shutting down the Graham ICO. And so I don't want the judge, but that's very different facts. It was an ICO, and there was initial purchase agreement that the Graham token holders signed. Like there's actual contracts. Well, if there's an actual written contract, that might be a good sign of an investment contract. Very different scenario than what we faced. But I'm very concerned that because he was accepted before, that we need the court to know that this isn't, this isn't the Graham case, the Telegram case, and there's so much more evidence. So, but it's very foreseeable with the quality of attorneys that the judge has, that Ripple has. The judge could say, I'm just going to, not let Deaton participate on this one, but you can participate at the summary judgment level. Or she could agree with me and say that there's no harm in listening to what I have to say too. But just think about this, and it's why I tell people that, that you're allowed to stake and collateralize your XRP. That fact alone means you benefit a financial benefit. You receive a financial benefit, a profit from the token itself, independent of Ripple. That makes XRP a commodity, or some type of commodity-like asset and not a security. Now, so it really helps focus the court that the only chance that the SEC has is to say that this specific options contract to some venture capitalist for, 6 cents, 8 cents XRP for a $20 million investment in 2014, right, or something like that, that particular sell and transfer constituted a security. But
hey, can y'all hear me?
Yeah, go ahead.
Hey, I just came in out of the rain. Look, I came out of the rain here. I was in an Uber just now, and there's only one thing I'm picking up here after listening to John talk. I'm feeling like John is smelling some duty here. Is that true, John?
Yes. Absolutely. Every pun intended.
Okay, no, John,
it's bullshit. I mean, he
believe it or not, tomorrow morning I'm picking up full throttle on this story, and I'm in a packed restaurant. I just got out of this cab, and I'm sorry I wasn't able to contribute more, but I'm like, it's like really loud too.
Well, here's what I can tell you is that I would tell the judge, and I've said this to a jury before. When you take someone with his credentials, and I'm sure he's got an impressive education and he's got this on his resume, at the end of the day, his opinion is what we call a swag. And that means a scientific wild-ass guess. And that's what, in essence, he's being offered to do. He's guessing. He's saying that XRP holders, because, and then, again, that they had to rely on Ripple in order to, by relying on Ripple to give them their financial benefit, therefore it's a security. And so, my focus is going to be 100% on the secondary market sales and XRP holders. And
You didn't talk to me.
The briefs for Daubert are due July, and the responses are due August. When a judge is going to give a written ruling, is anyone's guess. And so I can never predict that.